Every day in the USA, people find themselves in court.
This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Wendy Scott. It's case number 2024 CR 346. James Watts appears as defense counsel. Wendy Scott appears from the Butler County Detention Facility's Zoom location. Amber Norris appears for the state of Kansas. This matter comes before the court at this time for pretrial conference. Court noting that the matter last came before the court on October the 30th. An evidentiary preliminary hearing was held. At that time, the state had moved to amend count 1 to aggravated kidnapping and count 5 to felony theft. Those requests were granted. The court found probable cause on all 6 charges. At arraignment, the defendant waived reading, entered a not guilty plea. Pretrial conference was set for today, with jury trial set to begin on February 25 at 9 o'clock. Requests for furlough and bond modification were denied by the court. With that recap, Mr. Watts, what is the current status of the case and what announcement is made?
Your Honor, the state had made an offer in this case, an offer that's consecutive, or not consecutive, it's the same as the offer made the co-defendant, Ms. Rogers. My client, I understand, wishes to enter a no contest plea accepting that offer. That offer is to count 1 as originally charged, which is kidnapping as a level 3 offense, as well as count 3 and count 4, all concurrent mid-box. We do reserve the right to seek departure. I assume the state will oppose that departure. I would expect the state would oppose that departure. I think that's all I have, Your Honor. Thank you.
All right. I want to make sure that I'm aware of what charges your client's conceivably going to be pleading to. Count 1 then would be kidnapping, a level 3 person felony. Count 3, criminal threat, a level 9 person felony. And count 4, aggravated robbery, a level 3 person felony. Is that your client's intentions?
Yes, sir.
All right. Ms. Norris, has Mr. Watts announced consistently with your understanding as to how the Scott case would be handled?
Yes, Your Honor.
All right. Ms. Scott, I've got a number of questions I need to ask you regarding the taking of a felony plea. If there is any question asked of you that you do not fully understand, I would give you the opportunity to confer privately again with your lawyer at any point if you need to get further advice along the way. Okay?
Yes, sir.
Just let the court know if you need that time.
Yes, sir.
I'm going to start off by having you state your full legal name for the record.
Wendy Sincere Scott.
How old are you right now?
I'm 40 years old.
What's the highest level of formal education that you've attained?
11th grade.
Now, do you believe you're going to have difficulty understanding any of the legal concepts we're going to be discussing in court here this morning?
No, sir.
Have you ever been adjudged to be mentally ill?
I have depression, anxiety, depression. I take mental health meds for.
Are you getting those mental health medications in the jail?
Yes, sir.
Do they help you and improve your mental state?
Yes, sir.
Okay. All right. Do you believe you have a full understanding of what's going on here in court?
Yes, sir.
All right. And you can tell the court then that you're not under the influence of alcohol or any drug?
I'm not under the influence of anything.
All right. Now, did you receive a copy of the original charges in this case?
I think so. From the jail, I think that they gave me just a paper. It is like it was, yeah, when I first came, I still got that paper.
Okay. Do you understand the nature of the charge of kidnapping that would be in amended count 1?
Yes, sir. Yes, sir.
Do you understand the nature of the charge of criminal threat in count 3?
Yes, my attorney explained it all.
Okay. as he should.
Yes.
And do you understand the nature of the charge in count 4, aggravated robbery?
Yes, sir.
All right. You understand that when you enter pleas of no contest, you are not necessarily admitting that you did these things, but you're also not contesting that you be convicted of these offenses just the same. Do you understand that? Ms. Scott?
Yes, sir.
All right.
I didn't know if you heard me. I'm sorry.
I did not. So I would appreciate if you'd speak up when you answer. I just want to make sure all participants can hear your responses to the court's questions.
Yes, sir.
All right. You further understand that when you enter pleas of no contest, you'd be giving up any legal defenses that you might have had to those charges.
Yes, sir.
Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses with the assistance of your attorney, Mr. Watts, and present evidence on your own behalf and subpoena your own witnesses to court?
Yes, sir.
You also understand that at such a trial, you personally would have a privilege against self-incrimination, which means that if you wanted to testify in your case and tell your side of the story, you could at your choice, but no one could force you or compel you to testify against yourself if you didn't want to. Do you understand that?
Yes, sir.
You understand that when you enter pleas of no contest, you give up these valuable trial rights that the court has described.
Yes, sir.
Are you also aware that you have a right to a trial by jury, and that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt?
Yes, sir.
Understand that when you enter pleas of no contest, you give up your right to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt.
Yes, sir.
Do you understand, Ms. Scott, that you have a right to appeal a guilty verdict if you have a trial?
Yes, sir.
Do you further understand that you may appeal your sentence after entering pleas of no contest, but generally you may not appeal your judgments of conviction after you enter such pleas?
Yes, sir.
Are you aware of the possible sentence that could be imposed as a result of these pleas that you're attempting to make?
Yes, sir.
Let's go over those. Level 3 felonies in Kansas would be on the non-drug offense grid. In the most favorable criminal history category of I, you could receive as little as a 55-month prison sentence. In the worst criminal history category of A, you could receive up to a 247-month sentence. So the sentencing range for level 3 would be 55 to 247 months in prison.
Yes, sir.
A level 9 felony, such as the criminal threat, in the most favorable criminal history category of I, you could receive as little as a 5-month prison sentence. In the worst criminal history category of A, you could receive up to a 17-month sentence. So the sentencing range for a level 9 felony is 5 to 17 months in prison. Do you understand that?
Yes, sir.
You also understand that you could receive up to a $100,000 fine for a level 9 offense.
Yes.
You also understand that you could receive up to a $300,000 fine on a level 3 offense.
Yes, sir.
Ms. Scott, I need to point out to you that at level 3 on the non-drug offense grid, any level 3 crime would be presumptive prison under Kansas law. Do you understand that?
Yes, sir.
Do you understand the difference between consecutive and concurrent sentences?
Yes.
Let's go over that. Concurrent sentences mean that they run all at the same time. When you're serving one, you'd also be serving another. Obviously, that would result in a much shorter overall sentence. Consecutive sentences are boxcard, back to back. You have to serve all of one before you even start serving the next, which would obviously result in a much longer prison sentence. Do you understand, Ms. Scott, that regardless of any plea agreements that's been reached, it's up to the court to determine whether your counts run concurrently or consecutively?
Sir.
Ms. Scott, I also need to point out that the Kansas Sentencing Guidelines Act has what we call special rules. If any special rule applications would apply to you in your case, do you understand that it could affect your sentence or affect your ability to be put on probation. You understand this?
Yes.
All right.
I have a question. You said special rule?
Yes.
What did that, like a special rules, like if I haven't heard of a special rule on my case?
I don't know that one would apply, Ms. Scott. I
Okay.
just need to make you aware that the Kansas Sentencing Guidelines Act is just a big book of sentencing rules and laws. And among those, there are some special rules that sometimes come into play.
Oh,
Generally speaking, your attorney will be aware of special rules that might apply to your case, and he would have discussed those with you.
okay. No, you
If
did.
he
And
didn't,
Your Honor,
okay, go ahead.
I'm sorry, Your Honor, I would note, I'm not aware of any special rule particularly that's likely to apply here. As far as I know, she's not on probation or parole at this time or anything, so I don't know that there's one that really applies here.
Ms. Scott, are you satisfied?
Yes, sir.
All right, then let's go further.
Mhm.
You also understand that in addition to any fines that might be imposed, you could be assessed and be required to pay court costs, certain fees, and restitution to victims, if any are owed, as part of your sentencing orders.
Yes, sir.
You also realize, as a direct consequence of this plea, you will be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision, which is your state parole time that you do after you get out of prison, as
Mhm.
deemed appropriate by the court at time of sentencing.
Yes, sir.
You also understand that both probation and post-release supervision periods generally start at 12 months in duration, but can run up to 60 months under some circumstances.
Yes, sir.
Some of those circumstances might actually exist here. Do you understand that?
Yes, sir.
All right. Now, Ms. Scott, do you feel like that you've had an ample opportunity to discuss legal matters and sentencing options fully with your attorney, Mr. Watts, before proceeding here today?
Yes, sir.
You want any more time with him privately now before we go further?
Um, no,
All right. Are you satisfied with the services and advice given to you by your attorney?
I am.
Now, Ms. Scott, this no contest plea set that you're attempting to make, has this been based on any threat or promises as to what this court will do in regards to your sentence or any other type of threat or promise?
No,
Ms. Scott, is there anything else that you thought was part of this plea agreement that hasn't been accurately discussed on the record already?
no.
All right. Now you understand that if there are any plea deals between your counsel and the county attorney's office regarding sentencing recommendations, that this court is not bound by any agreements made. The court may and shall consider them as recommendations, but is not bound by them. Do you understand that?
Yes. So I have a question. So when we get plea agreements, we don't get that? We don't
It
get what,
doesn't bind the judge.
oh,
It
okay.
binds the prosecuting attorney, perhaps might require her to make certain recommendations or remain silent on certain things, but it doesn't bind the court. That's what I want to make sure you understand.
Okay, yes.
All right. So, Ms. Scott, how do you formally plead to the charge in amended count 1, kidnapping, a level 3 person felony,
No contents.
and to count 3, criminal threat, a level 9 person felony,
No contents.
and to count 4, aggravated robbery, a level 3 person felony?
No contents.
All right. I'm going to ask the state for a concise factual basis as to each charge.
Your Honor, on July 20th, 2024, the defendant did take Ms. Zilke by way of her vehicle from her apartment in Wichita into Butler County, where she did threaten to cause her harm and did forcibly remove her from her vehicle, the gray 2024 Nissan Altima, and did take that and her purse and a dog in the process and left her on the side of the road. And that was near 12928 Southwest 120th Street, Augusta, Butler County, Kansas.
Okay. The taking originally was accomplished by what means?
The taking of Ms. Zilke or the taking of the vehicle?
The taking of Ms. Zielke.
It was, they asked for a ride, and initially Miss Silky thought they were going to, was basically taking them to a hospital, and they kept giving her basically false directions, which led them into Butler County, and they kept giving her further directions that got them even deeper into Butler County. And she basically then was concerned. So basically they deceived her in where they were going. And then once Miss Silky figured or thought something was, it didn't seem right, then she questioned them, and then the threats and the taking of the vehicle and the other part of it occurred.
All right. So the taking of the person of Ms. Zielke was done by deception.
Yes, Your Honor.
All right. Now, the specific criminal threat, I understand that you mentioned threats, but what oral statements were made that could be construed as a threat under these circumstances?
Your Honor, they did have I believe they did have a firearm, and they did threaten to shoot her or do harm to her with the gun if she didn't well, if she didn't give them the vehicle or whatever else they wanted.
All right. Thank you. And I see that that same language is included in count 4 on the aggravated robbery charge. That they took the motor vehicle by force or threat of bodily harm. What was the bodily harm inflicted on Beverly Zielke?
Your Honor, she did have some scrapes and some bruises from where she was basically pulled from the vehicle and ended up in the roadway.
Okay. So they literally dragged her out of the car and
Yes, Your Honor.
put her on the ground?
Yes, Your Honor.
Wow. All right. Very well. All right. So, Ms. Scott, at this time, are you making pleas of no contest freely, knowingly, and voluntarily, and accepting conviction for, in count 1, kidnapping, a level 3 person felony, count 4, aggravated robbery, a level 3 person felony, and count 3, criminal threat, a level 9 person felony?
Yes, sir.
Mr. Watts, do you know of any legal reason why the court should not accept this defendant's plea?
No legal reason, Your Honor. Thank you.
Ms. Norris, are you aware of any such legal reason?
No, Your Honor.
Wendy Scott, are you aware of a legal reason or any other good reason why the court shouldn't accept your pleas of no contest this morning?
No, sir.
Court will accept the no contest pleas made by Wendy Scott and finds that those pleas are made voluntarily. She has an understanding of the nature of her charges and the consequences of her plea, and a factual basis for the pleas does exist. The court finds the defendant guilty, and the judges are therefore convicted of the crimes of kidnapping, a level 3 person felony in count 1, criminal threat, a severity 9 person felony in count 3, and aggravated robbery, a severity level 3 person felony in count 4. All other charges of the charging document are dismissed pursuant to plea agreement. Court will order a pre-sentence report be completed to accurately determine Ms. Scott's criminal history, and the court will set an appropriate date for sentencing. Ms. Scott, if I had my preference, we'd go ahead with sentencing today, but we really can't do that. There has to be a research of your prior criminal history. That takes time. We generally allow about 2 months for completion of that report. If you're asked to do any assessments of any kind, I will expect you to fully cooperate with those assessments, but I will set a sentencing date about 2 months out, and then you'll be sentenced at that time. Counsel, that will put us mid to late April. One date I was looking at, Mr. Watts, was Friday, April the 18th at 1:15 p.m.
Yes, sir, I can do that.
All right. Ms. Norris, I trust that'll work for you.
Yes, Your Honor.
Sentencing in the Wendy Scott case will be Friday, April 18th at 1:15 p.m. Would you expect that there would be a victim statement?
Yes, Your Honor.
All right. I think we can still go ahead and conduct this proceeding by Zoom. I know Ms. Scott is in custody. And I do recall that Ms. Zielke is elderly. I believe Zoom might accommodate her better. Friday, April 18, 1:15 p.m. will be the Wendy Scott sentencing. All right. I think my assistant will go ahead and notify court services at the conclusion of this hearing. I know Ms. Scott's not in a position to meet with them or call them at this time. And I think she can give them the basic information regarding the need for a pre-sentence investigation and report. So thank you for doing that, Mandy. Friday, April 18, 1:15 p.m. for sentencing in the Wendy Scott case. All right, Ms. Norris, is there anything else that we need to address currently regarding Wendy Scott?
No, Your Honor. Thank you.
Mr. Watts, anything further at this time?
No, Your Honor, thank you.
Very well. Ms. Scott, you have any questions about what we've done here today?
No, sir.
Very well. Then if there's nothing further, the Wendy Scott matter will currently be in recess. I'm sorry.
Asking my lawyer, can he come and see me too?
I can.
Thank you.
All right. Thank you.